Hello, welcome back to the Educated Franchisee series on FDDs. This is part 2 of a 6-part series. My name is Rick Bizio. I'm the author of The Educated Franchisee and a franchise coach. I work with individuals who are interested in learning more about franchising, and I have on my guest speaker is Nancy Leonard. Say hi, Nancy.
Hi, how are you?
Doing great. Nancy is the principal for Leonard and Associates. She's been involved in franchise law here in the United States for over a quarter century, has extensive experience, and her entire law practice is dedicated only to working with franchisees, which is, believe it or not, something that's a little bit unusual. Most law practices work on both sides or just on the franchisor's side. Nancy worked exclusively on the franchisee side. So she's exactly the expert we want to be talking to. In this particular session, what we're going to do is talk about the item numbers, the first item numbers in the FDD. So the last time we talked about some of the basic FDD, what it is. Now we're going to start getting into the item numbers. And we're going to start with item number 1. The first item number you'll run into, which is the franchisor, its parents, its predecessors, and its affiliates. And so whenever you open FDD, that's the first thing. Doesn't matter what the industry is. That's the first thing you're going to see on the table of contents. And the information in each of these item numbers is going to be kind of prescriptive in regard to the information that's provided. And so, Nancy, maybe walk through a little bit the basic information that you would normally find, and any highlights that you would suggest that they pay attention to as they read it.
Yeah, so item 1 is very important because it gives a lot of background about the franchise company itself. It talks about whether there are any affiliated companies to the franchisor, whether there are parents or predecessor companies to the franchisor. So it gives you a little bit of history, a little bit of background about that franchisor. And even more importantly, I think, are the provisions that it talks about any kind of competition and regulations in the industry in that section. And so I think that's very important. If you're in a particular field like early learning, an early learning program franchise, understanding that there are regulations and what types of regulations you might encounter as a franchisee that you need to be thinking about and aware of, I think is a very important thing to know. And so item 1 will tell you those kinds of things. Also, I skipped over about the parents, predecessors, and affiliated companies, but that's really important to know too, because sometimes, and not unusually actually, the trademark, which is the brand, it's the logo, is owned by an affiliated company, not by the franchisor directly. And so the way that works often is that the affiliated company that owns that mark will license the rights to the franchisor, who then further licenses the rights to each of its franchisees. So again, that's something to know, because if that affiliated company is sold, what happens to your rights to that mark? How does that work? So it's just important information for anybody to know.
One of the things I think about item 1 sometimes is when you see a predecessor company, I almost always will do some research on the predecessor company and see what happens. Sometimes there was a name change. Sometimes the brand name changed, but it's the same system and they've recast it a little bit. Sometimes understanding what happened in that predecessor situation gives you an insight into a longer history.
No question. No question. Sometimes it also tells you whether there's been a bankruptcy. It's very possible that the predecessor company was a company that went into bankruptcy. So what does that say? And what does that tell you as a prospective franchisee looking to invest in this opportunity? Absolutely. So I agree with you. That's valuable.
Yep, absolutely. Let's talk about item 2. Item 2 has to do with business experience. Walk us through it.
So item 2 is just a disclosure of the principals that you will be dealing with as a franchisee in their system. Who's the president, CEO, who are the people that are going to do the training, who are the principals involved. And it's very telling, because you want to see that these are not fly-by-night people. You want to see that these are people that have been with this business in some capacity for a while. Even if it's a brand new system, a brand new franchise system, it would be nice to see that they have a background in something that's what's that?
Relevant.
It's relevant. Exactly. That's what I was going to say, that has something to do with whatever it is that the franchise is selling, so that they're knowledgeable or that have a strong business background. as opposed to just being, people with money that put money into the business. So yeah, it's telling in that sense. It's probably not the most important item out there, but I think it's a value to see. And certainly, you certainly want to see that these are qualified people to be running the business, because this is who you as a franchisee are going to be working with.
Absolutely, absolutely. Talk to me a little bit about item 3. Now, item 3 is litigation.
Yeah,
And that's the
item 3.
interesting one.
Yeah, that's right up my alley. I mean, that was, that, not that I'm a litigator, I'm not, but that obviously is one that we take very, very seriously when we're going through any review. And item 3 is very important. And if you see a tremendous amount of litigation, and by the way, not every lawsuit that the franchisor is involved with, or that a franchisee in the system is involved with, is going to be is required to be disclosed in item 3. It's really ones that relate to the relationship between a franchisor and franchisee. So any claims of fraud or misrepresentation or violations of any franchise laws, those would be in item 3, for example. And it's obviously very important. And if you see a lot of item 3 disclosures, it might be a red flag. It might not, but it might be. And what I think is also really important and people don't realize is, and this goes back to the entire FDD, and that is that even in the states that require that the FDD be registered with them and that they examine it, they're not auditing every single word of that FDD or numbers that are put in the FDD. So when we're talking item 3, it's very possible there are lawsuits that a franchisor has not included in item 3 that should have been. And if you take item 3 at face value, you can certainly see if there's any red flags there, but you may not know that there might be other lawsuits out there that should have been in there. And also you're reading their summary, their lawyer's summary of that lawsuit, which may or may not, there have been lawsuits over item 3 lawsuit descriptions as to whether they were even accurate or whether they were misleading.
How long does an item have to remain in there? If, let's say, it's been resolved, somebody paid somebody money, but it's done. How long does it have to stay in there?
Yeah, and that's a good question.
I believe it's 10 years, isn't it?
Yeah, well, it's 10 years for the, I have my resource guide right here. Out by NASA that I talked about in the first segment. So let me find that out, because as I said, I represent franchisees these days, not franchisors. So I don't really have to even worry about that so much, but let me see if I can get an answer for us real quickly here.
Yeah, as I recall, and again, I'm not an attorney, but it seems like anything that's ongoing has to be disclosed, and anything that has been resolved over the last decade needs to remain in there, because I've seen stuff in there that's at least 10 years, that's up to 10 years old.
Ongoing for sure has to stay in there. Until it's resolved, it definitely has to be in there. That I don't have to look up. I know that the disclosures of what's in item 2, as far as the people and their job history, has to be 10 years. I'm not 100% on 3. And bankruptcy, I'm pretty sure, is 10 years. The disclosure. The litigation part, I'm not 100% sure, but I can certainly let you know.
Okay, I think that it's, if somebody needs to figure that out, we can look it up for them later. The reality is that it has to stay in there for a period of time.
Exactly. It's not just the ones that are currently there. Right. It has to be ones from the past. And if they've been resolved in some fashion by settlement or by finally litigated, then that would be disclosed in there as well.
Let me ask a different question.
Yep.
Is all litigation bad? If you see litigation in that,
no, not all litigation is bad, because sometimes it's the franchisor enforcing their trademarks, or the franchisor enforcing their rights against a franchisee, or a franchisee enforcing their rights against a franchisor. So no, not all litigation is a red flag. Not all litigation is bad. That's why when we go through that, we are very careful to identify what's a red flag, but not everything there is going to be a red flag.
Sometimes you need a franchisor that's going to enforce its rights. If you have a neighboring franchisee that's injuring you and injuring the system, you want the franchisor to make sure that stops.
Well, encroachment. If there's an issue with somebody encroaching on your territory, and that's brought against you you bring it against the other franchisee, and maybe the franchisor hasn't enforced it, so you bring it against the franchisor. Is that a red flag? I don't think so, per se. That's
absolutely. Let's talk about bankruptcy. Let's go to the next one, because you could talk about litigation all day, I know. So we're going to move you on.
So bankruptcy is
this is item 4, by the way. Item 4.
Item 4. So again, that's something that has to be disclosed both for the franchisor's history as well as for those that are disclosed in item 2. So for the individuals that are in item 2, which we talked about, those are the people that are going to have primary contact with the franchisees. If any of those have a bankruptcy in the past 10 years, those would be in item 4 and disclosed in there. Now, similar to your question about item 3, does that pose a red flag necessarily? And, it depends on what it is. If it's a bankruptcy of that particular company, the franchisor, it depends. If it was Chapter 11 where they reorganized and then came out of it, sometimes businesses come out of that much stronger. Sure. And might be in a healthier position than they were before they went through the bankruptcy. And that's part of what they do. They reject some of the leases, if they're brick and mortar, that they had for their corporate locations. They sell off some of the assets, and they become stronger and healthier because they've done that and they had that opportunity. So it's not necessarily always a bad thing, but you have to really look at that. I went through a franchise bankruptcy. I was in-house counsel 25 plus years ago to Nutrisystem when they were, had been around 20 years, and they had 1,300 1,300 franchise locations and 500 corporate locations. And they were the #1 weight loss company out there, but they went into bankruptcy, and it's not a good thing. I can assure you, because within a couple of years, all those franchisees were out of business. So it's a little bit scary, but that would have obviously never been disclosed because they went out of business shortly after it happened.
You may not know this about me because I know we've known each other a long time, but I got started in franchising in 1993. And I was hired by AFC Enterprises, which is Popeyes and Church's and Seattle's Best Coffee and Cinnabon back in the 1990s. And Popeyes and Church's had just come out of a bankruptcy in 1992 with Friedman's Fogli and the CIBC and Al Copeland and that whole thing. And at the time, of course, it was a giant red flag for folks. But if you look at those brands today, they've actually expanded quite well after that. It took them a while to get back under their feet, but the bankruptcy, it can be a really bad thing. It can completely destroy a company. In other cases, it can be a good thing. The one thing that I say is a lot of people spend a lot of time looking at bankruptcy, and they call me up and they're like, look, I looked at this thing, and do you realize that their manager of marketing had a personal bankruptcy in 2008? I'm like, I'm not positive that's important to the viability of the business opportunity. But there are other things, of course. If it was the president and he had it last year, that might be a different story. So especially if the president owns the majority of the company.
Yeah, I agree 100%. Exactly what you said. And in the case of Nutrisystem, by the way, they were bought out of bankruptcy and became an internet-based weight loss program that you see advertised on TV all the time. So they came out of it. They're strong. It's just not a franchise system anymore.
Absolutely. Super. Well, that is the end of part 2. We're going to close it out. Again, our contact information will come up at the end of this video. We're going to move on to part 3. Part 3 is going to really just start with item 5 and carry on. Thank you.